Good morning, everyone, and welcome to this legal compliance session on COVID workplace laws run by Kaizen Synergy Law Firm. My name is Nihal Samara. I'm the General Counsel and Legal Director here at Kaizen Synergy, and I'd like to welcome you all to today's session. Today's session starts the series of these legal compliance webinars specifically focused on what we'll call coronavirus or COVID workplace laws right around the country. I will add that the information that we have sourced for these slides has come from a number of different key sources. We do acknowledge fair work in relation to the information where we have pulled a lot of this information across, but we will be also talking through across safe work requirements, anti-discrimination laws, and we will be referencing specific government regulatory agencies as we go and move throughout these webinar series. We will be running these over the next few weeks, probably all the way through to the end of March, at least for the next 4 weeks, because there is a lot to actually unpack, which I'm going to start in today's session. It will specifically focus on key areas around workplace laws that each of your agencies need to be aware of and also comply with in specific situations. So as always, we'd like to pay our respect to the elders past and present upon the lands on which we all meet. While this session is being run by webinar and recorded, we do pay our respects to the traditional owners accordingly. So today's agenda really starts off a number of key areas that we are going to unpack, and as we look at accordion out a number of these key areas. One of the biggest issues actually facing agencies is workplace rules and regulations in dealing with COVID within the workplace. This will cut over into areas like work health and safety, anti-discrimination. It will also cover off things like risk and reporting within your agencies as well too. So to start off with, we are going to look at just the first topic around COVID-19 vaccinations, testing and the workplace, and including some of the changes to workplace laws that your agency needs to be aware about. It would be simply far too much to actually cover off each and all of these topics in one single session. So we are going to break it down into a number of key areas, as you can see here, and each week essentially unpack a number of rules, requirements, but also give you a set of resources that you can actually start to use across your agency from week to week. Of course, there are rules and laws that are changing. We are seeing the easing of restrictions, the changing of things like mask mandates, for example, in Victoria, but there are differences across different states that we're seeing equally around Australia as well too. So on this basis, we are going to specifically look at rules that you need to follow and be aware of based on your specific jurisdictional area. With it, it is things that you need to be very mindful of. And with it, it is something that we will cover off as the rules change over the next few weeks for you as well too. So the challenge and why we are running these legal compliance webinars, just to give you an idea of how we're seeing this unfold, and most of you may already have experience in dealing with some of these as well too. So if we tick and open up, let's say, the first topic that we're looking at today, well, essentially what we see here, it's not just a linear and single approach that we need to consider. Essentially, we need to look at, well, what is the vaccination and testing requirements within the workplace? How do you then resolve some of the workplace issues? What are the directions that you need to consider, as well as some of the legislation and public health orders? And each of these accordions out its own separate issues and challenges that you need to be aware of. And particularly, we're seeing this from where the challenges are for agencies, particularly where we've been involved with supporting agencies in fair work disputes and issues as they've come up in the last 6 months. Specifically, there's been an increase in these, or people threatening essentially class actions and the likes. So we are talking from experience here in what has worked with agencies, what we've actually put in place, what we've recommended, and also addressing fair work disputes before they essentially happen. So some of our recommendations, quite simply, right up front, is to review your COVID vaccination testing and workplace policy documentation. We will be looking at exactly what these look like and unpacking these for you as well too. So let's jump into it. Essentially, we are now seeing changes in booster and vaccination rules, and essentially there are some directives that are issued right around the states and territories where there are changing rules and there are exemptions available for workers in particular industries who have, for example, a medical reason for not receiving the COVID-19 vaccination. And we're seeing these right around the country, across the ACT, right across to WA and the likes, but there are directives that your agencies need to be aware of. Now, if we're looking at the first item here, and as I said, we're literally over the next few weeks going to unpack these part by part in terms of what responsibilities your agency has and what you need to know about moving forwards as well. So when we're looking at COVID-19 vaccination, workplace rights and obligations, we need to look at what is it that requires employees to be vaccinated, what happens if there's a refusal around directions to be vaccinated, how do you manage vaccinations in the workplace, and what is the evidence that you can ask for in providing these vaccinations. We are also going to touch on screening as well too within this session too. So essentially, in some cases, clearly employers like your agencies may be able to require your employees to be vaccinated against COVID-19, including where a specific law, such as a public health order, requires it. Employers really should look at getting legal advice if they're considering requiring COVID-19 vaccinations in the workplace. Now, when we talk of these things, this actually does not only cover places like healthcare and aged care services, but also job placement agencies, apprenticeships, schools as well too, where you may be an RTO or the likes, or you may have a registered training organization. Excuse me if I start to use acronyms. By all means, use the chat group or questions to raise any items that you would like as well too. And I will get to those as we go out throughout today's session. So even if you have students coming in to your workplace, there may be policies that you need to inform the registered training organization or RTO or university on about specific policies that you have in place. There may be some areas that you are essentially covered by a public health order. We will cover off some of the challenges around having the mandatory vaccination policy. Of course, there may well be staff that have held out for the different vaccine that is available. You may have staff also that are not wanting to have the vaccine and maybe working from home under specific orders. So essentially, employers can only require their employees to be vaccinated where there is a specific law, such as a state or territory public health order, and it requires it, where the requirement is permitted by an enterprise agreement or registered agreement or an employer contract as well. And I will add that a lot of the employee contracts we've actually worked with agencies to actually review, and where there isn't such a clause, actually put in or add an addendum into the contract to cover off specific COVID or what we've called pandemic clauses. So it might be force majeure events or the likes, and we'll look at some of those over the next few weeks, as well as policy documents and policy requirements that employees need to ensure that they abide by. But the reciprocal arrangement of that is that employers and agencies need to ensure that they consult with their employees on changes to COVID policies. And we'll come to that as well too. It also means that your agency needs to give your employees a lawful and reasonable direction to be vaccinated. Whether direction is lawful and reasonable is really assessed on a case-by-case basis. We will cover off some of the tier areas around this, because it is something that agencies often approach us on and say, well, only part of our staff is actually covered by a pandemic order. What does that in fact look like? So essentially, one or more of these circumstances can apply. For example, an agency could rely on a state public health order that requires your employees to be vaccinated to give the employee a lawful and reasonable direction not to work unless they are vaccinated. Now, you need to consider carefully anti-discrimination laws as well as work health and safety laws as well too. Now, when we look at anti-discrimination laws, there are protected characteristics that people may have, and that includes, for example, if people are pregnant, if people have a disability, or some other protected characteristics as well too. We will add that while a protected characteristic in the past under anti-discrimination laws could have been things like your people's individual political views, it is not something that is really covered within these vaccination rules. And that's something that across the board, human rights and anti-discrimination regulatory agencies or commissioners have quite openly stated in some form or another. There is the rules around work health and safety requirements as well, where you do need to consult with your employees. Too often we've found that agencies have just simply sought to initiate a policy around this without actually having that appropriate consultation. And a lot of agencies will come back to us and ask us, well, what does appropriate consultation mean? Usually it is what we call, and you'll see this within work health and safety rules, it is around being reasonable and practicable in terms of your WHS. And that's an underpinning sort of statement that a lot of work health and safety rules, you'll see that what's reasonable and practical. Now, based on that, generally what it'll depend on when was the public health directive issued, depending on the timeline. Usually we work on about a 4 to 8 week period around this. It also may decide on the size of your agency as well too. The idea is that essentially staff can ask questions and also pose or seek answers from yourselves in terms of any new policy that's coming up. And the idea is that you would then go through your policy approval process in terms of the vaccination stance that your agency may have around this as well too. Now, there are clear legislation and public health orders. I do acknowledge that at times legislation and public health orders do seem quite confusing. And where this confusion actually comes into is where they may list that specific areas or sectors are required to have a vaccination position in place for their employees, a mandatory vaccination position in place. And that might include places like aged care, quarantine and transport, healthcare, schools, and early childhood education. And employers and workers need to comply with any public health orders and directions to apply to them. Where we find the confusing part for agencies, though, is where your agency may have multiple program streams. So you may be providing aged care, but you may then also provide services that are not listed within the public health order. And agencies approach us and say, well, how does this look? What does it mean for admin or reception staff where we don't fit in clearly into one of these public health orders? Or if for example, you're providing brokerage services for an agency that may be covered and another one that isn't. What does that then look like for your staff, where they may be under casual or part-time kind of positions? And so this is where it does get quite confusing. And with that, how we've actually looked at this is to work through these on a case-by-case basis, depending on the service profile that your agency delivers. But essentially where we start from is the relevant legislation that's based within your agency. The other things to look at is around, which we've covered off, is things like agreements and contracts. Now, some employment contracts or agreements may have terms relating to vaccinations, including COVID-19 vaccinations. Generally, what we have done is to start to steer agencies, rather than call it COVID-19 vaccinations, we've made the reference to pandemic vaccinations, which essentially, it's not to try and broaden it, but to give it some context around, well, if there's a new iteration of COVID-19, then your agency is essentially prepared for it. But the definition is based on the current pandemic that we've seen so far. So essentially it is to check to see if any terms apply to COVID-19 vaccinations, but it's mindful to be careful that a term relating only to flu vaccinations won't automatically apply to COVID-19 vaccinations, and that is something for yourselves to be mindful of. Equally, employers can include a term in employment contracts for new employees relating to COVID-19 vaccinations. And even where a contract or agreement has a term about COVID-19 vaccinations, you need to consider whether there is any anti-discrimination laws and it is inconsistent with it. So if a person may appeal on religious grounds, that they are protected for reasons that they might have a disability, or there might be a person who's pregnant as well too. All of those are examples of anti-discrimination requirements that you can't force on somebody because your contract, even though it has a clause about having the COVID-19 vaccination, doesn't automatically allow it because of existing anti-discrimination laws. Now, one of the things that Fair Work has also provided direction on is to look at tiers within your agency. And this is something we're just going to start talking about on this particular legal webinar. And we're going to continue to bring this across when we talk of tiers into the other subsequent sessions that we are running on Tuesday over the next few weeks. So essentially, an employer like your agency may be able to give their employee a lawful and reasonable direction to get vaccinated, even if there is no public health order, agreement, or contract with terms about COVID-19 vaccination that applies. So you can actually give a lawful and reasonable direction, even if there is no public health order. Now, I will talk over this because this is taken from Fair Work around this, but over the last number of sessions that we have run, we have focused on, well, what does that actually look like? Where would you potentially give a employee, as from your agency, a lawful direction? Now, whether a direction is lawful and reasonable depends on the individual situation. And when Fair Work talk about a case-by-case basis, what we actually have looked at is, well, what are the types of services that your agency is delivering and who does it cover? Now, when we look at, for example, a TAGI and their guidelines issued by and with the Commonwealth Government, it has focused for, I'm going to say, a number of years now on vulnerable population groups. Now, essentially, if your agency is delivering services to vulnerable population groups, then there may well be a position for you to have and change your vaccination position. Now, I will add that when we talk of vaccination policies or positions, it is something to be mindful of, that this is not just set in stone once and that's all that you do forever and a day. What we have recommended to agencies is that you review these policies from anywhere from 3 to 6 months periodically. At the moment, a lot of the agencies that we work with right up until November last year, we've actually put a hold on some of their policy changes. And only now are we actually looking at changing those now. And that's really based on the upcoming few weeks that we are going to cover off these specific topics that agencies need to be aware of. Now, just because it may be lawful and reasonable to give a direction to an employee to be vaccinated doesn't mean that it will automatically be lawful and reasonable to give the same direction to another employee. Now, what do we mean by that? Well, essentially, the direction needs to be lawful. And when Fair Work talks about, well, what is a lawful direction? And you're going to see us repeat this over and over again in the next few weeks as we unpack the workplace laws that your agency needs to be aware about. Now, for a direction to be lawful, it needs to comply with any employment contract, award, or agreement, and any Commonwealth, state, or territory law that applies to your agency. Now, that is one of the broadest statements I think Fair Work can actually give, because literally it needs to be, they may as well say it needs to be lawful with everything. Because for a direction to be lawful, it needs to comply with the contracts, awards, or agreement, as well as any Commonwealth, state, or territory law. So what does that mean for you? And how can we make this a lot simpler? Well, excuse this slide, but it is something that we're just going to work through, and it is something that you need to carefully look at. Now, there are a range of factors that may be relevant when determining whether a direction to an employee to be vaccinated against COVID-19 is reasonable. We do have a checklist on this in Gemba as well too, which we will start to work through as well. I can just see that someone has just asked us where can I log in and where will I find this? So let me just do that for you right now. So essentially where you can go is directly to the Gemba dashboard, and you can log in to that. Let me just bring this up for you as well too. So if I bring this up, essentially you can go directly to our website and go to gemba360.com, or you can simply go to gemba360.com, and that will bring up this dashboard here. Now, for this, if you want to log in, it'll be asked for your email address, and I can just bring this in for us to have a look at. And here we are here. And where you will find these specific forms for you to use, if I log in, then where we can go when we log in, and you'll find them on the left-hand side of the toolbar that you can see here, along with all of our other resources as well. Now, within it, let me just go back to the slide. Essentially, things to consider is the terms of any public health orders, the timelines, and who is covered within those. Is there any WHS obligations? And we'll unpack those over the next few weeks. What is the nature of each workplace? So what are the services that your agency delivers? Is it to any vulnerable population groups that you need to carefully consider? What is the extent of community transmission within your agency? And this will specifically cover off whether you need to continue to screen your staff as well too, the effectiveness of vaccines in reducing the risk of transmission or illness. That's now becoming a very key point as we work through the workplace laws and also the transmission rates that we're seeing around the country. It means then that if the effectiveness of vaccines isn't actually reducing the risk of transmission, then there may be a variable that you need to consider within your agency as well too. You need to also look at each employee's circumstances, including their duties and risks associated with their work. And this might be how you actually set up different tiers for people to work across within your agency and fall within. And also whether employees have legitimate reasons for not being vaccinated, for example, medical reasons, and also the availability of the vaccine itself. Now, one of the things that we have done for agencies is to look at different tiers that they may work in. And what do we mean by this? Now, we have set up either tiers or what we call matrix models. And when we've looked at mandatory vaccinations within agencies. So what that means is that you may have 4 tiers, and this is also consistent with what Fair Work also says as well too. Now, to assist in assessing whether directing an employee to be vaccinated against COVID-19, it may be helpful as a general guide to divide work into 4 broad tiers. And you have tier 1, tier 2, tier 3, tier 4. Now, tier 1 means where employees are required as part of their duties to interact with people with an increased risk of being infected with COVID-19. And that includes people, for example, like quarantine, border control, but also healthcare workers directly, where there is that face-to-face contact. Now, you can then look at tier 2 employees, where employees are required to have close contact with people who are particularly vulnerable to health impacts of COVID-19. And this now really focuses on healthcare or aged care workers. We then have tier 3 workers, where the interaction or likely interaction between employees and other people, such as customers, just occurs in the course of their employment. And tier 4 is where employees have minimal face-to-face interaction as part of their normal employment duties, for example, where they are working from home. Now, you can start to see that this essentially tiers or matrix type of approach may mean that people actually fit into one or more of these particular tiers, or you might call them quadrants or the likes. It is actually a very effective way of looking at vaccination rules within your agency. We actually also use it for screening staff. So, for example, tier 1 and tier 2, clearly they would be screened on a regular basis as well too. Whereas tier 4, because they are essentially they've got minimal contact, where they are essentially working from home. So again, from a screening point of view, this actually has quite broader impacts in terms of who may be covered within your specific agencies. Now, one of the things that I'm just coming back to is does your agency need to consult with staff when implementing workplace policy about COVID-19 vaccinations? And the short answer is yes. We've just been asked a question of, does this include just paid staff, or does it also include volunteers as well too? For agencies, we have covered all personnel in this. So this does include not only paid staff, but also volunteers that you also need to engage with as well. So before implementing a new workplace policy or changing an existing policy about vaccinations, I will add that this also includes screenings. Employers do need to consider their workplace and employee circumstances, and also continue to engage with all of your personnel. It is important that, particularly under WHS laws, you do consult with employees and any health and safety representatives about possible control measures to address WHS risks. This does include when changing or making any new policies within your agency. And this does include around not only vaccinations, but also screenings. It is important to consider that if you are looking at changing these policies, as I mentioned, it is something that usually cycles around every 3 to 6 months, or unless there is a new pandemic order that is being released. We have just been asked also just in the question panel, does this mean changes if the pandemic laws are being loosened or relaxed? Yes, it does. So when we talk of consulting personnel about changes in policy positions, we're not just talking about mandatory vaccination pandemic orders, but if orders are being relaxed, and a good one is, an easy one is around the mask mandate in Victoria, for example, or if I can see also a question in WA, then essentially where you are relaxing those policy positions, it's equally important that you also consult personnel around that. So if, and I can see another question coming through, but the thank you, Franca, for asking this question, who's just asked, but the screening rules have changed. So what does this mean in terms of testing? So where the screening rules have changed, Franca, that's a good question around this. We are seeing that the daily attestation rules have been changed in some circumstances. What we have seen, though, is the rules around work health and safety not changing. So in some ways, there is this, what appears for many agencies when we've talked to them, this conflict of, yes, the pandemic orders may have changed the screening rules, but what does it mean from a work health and safety point of view? Under work health and safety, there is the requirement that agencies take reasonable and practicable steps to minimize COVID within the workplace. So essentially where we are looking at this, particularly in different workplaces, especially in health and aged care, and also education providers, where they're also placing students into health services and aged care services as well too, then there is still the need to minimize COVID within your workplace. So while the screening rules in some states have actually moved from mandatory to essentially the option for agencies, that option for agencies is still covered under your work health and safety obligations. So while the mandatory section of it under the pandemic order has been removed, essentially you've still got it under reasonable care under work health and safety obligations as well. Now, in terms of providing evidence of vaccination, this is now coming up because of the booster requirements that some people are being covered by. So one of the questions that still comes up is, can an employer require an employee to provide evidence that they have been vaccinated? Now, essentially the answer is yes. If an employer has provided a lawful and reasonable direction to be vaccinated for COVID-19, then the employer can also ask the employee to provide evidence of their vaccination. Now, with it, some agencies have asked us and said, but staff are unwilling to provide the vaccination certificates. How do we in fact treat them with it? Essentially, if they don't provide evidence of it, then you can treat them as unvaccinated. And that is something that we're finding in a number of different public health orders. And that's essentially an interpretation of the rule that you can ask for. And that's how you treat your employees around this. With it, what we are seeing as well, and it's a good question, thank you, Franca, around the privacy laws, which we will come to as well too. So what does this mean? So with it, an employer may ask to see evidence of an employee's vaccination status without raising privacy obligations, provided they don't keep a copy of or make a record of the vaccination certificate. What you do need to know is also if the requirement is that you do collect vaccination statuses from an employee unless the employee consents and the collection is reasonable. Now, what is interesting here is that this is a fair work directive, but also under some of the public health orders, there is the rule that it clearly states that agencies need to collect the vaccination of their staff as well too. So essentially, this is where we do need to look at some of the policies that your agency needs to put in, and also requiring not only the status of the employees or personnel, but also collection of those certificates as well. Now, it's a good question that has just been asked. Does this apply to contractors, casual contractors, or volunteers? What we are seeing under the public health orders, and I'm going to generalize here for a little bit, is that generally the public health orders in each state and territory are being interpreted very, very broadly in their definitions. What we are seeing is in some, and I'll use the Victorian one as an example, the definition of a healthcare worker, when you look at the public health order, is not for only those that are providing direct healthcare services, but specifically in the most recent one dated the 11th of Feb and the 4th of Feb 2022, we are seeing that healthcare workers are actually defined as administrative, IT personnel, security personnel, and also cleaning staff as well too. So you can actually see that this is actually very, very broad. The exceptions to that is dependent also on whether they are, and let me just go back to this part here, whether they're also listed within the different tiers. So when you look at some of these, and there's some work we've done with different agencies where we've looked at matrix or tier type of approaches, this is consistent with what we are still seeing with Fair Work around this. Now, what then counts as proof of vaccinations? Essentially, the directions coming out of Fair Work has said that Australians can access proof of vaccination after they have been vaccinated through the MyGov and their vaccination provider or the Australian Immunisation Register. So essentially what we are seeing across this is that essentially staff are being required to provide specific up-to-date requirements that we are seeing across the board for agencies. Now, just a couple of questions that are coming through around this is around, does this, is it appropriate to have a register without keeping the certificate? And aged care funding requires that everyone is vaccinated. That is also correct. So with it, certainly one of the things that you'll find that you are able to do, and again, looking at your GEMBA dashboard around this that you have seen as well too, and I will bring this up for you to view, is that when you click on your GEMBA dashboard, which all of you have access to, you can open up the HR module, and if I do this here, it will bring up this profile here, and essentially what you're able to do is update and to answer your question that I can see here is that you're then keeping a register of the information of the COVID-19 vaccination. Picking it up that once people have then had the booster, you can then list it up on here as well too, and this will then automatically send you out the reminders of when specific boosters are due based on a staff member's profile. So if they work in aged care, if they work in health, if they're a healthcare worker or education, childcare services, quarantine hotels and the likes, depending on their profile, it'll actually send them a reminder about what their current rules are, as what the current laws are based on their current position profile as it's required under strict interpretation of the legislation itself. So with it, I can see there's quite a few questions coming through, which I will come to here. With it, there is also the mandate, thank you, Franco, around answering this as well too. The federal government saying vaccination is double dosed, therefore the booster is not required. There is a change actually, Franco, around the definitions that we are seeing, where people are calling it, and we mentioned this in the legal compliance session and legal update that we have posted out to agencies as well too, where there is a move from fully vaccinated to up to date. And up to date definition is looking at the booster shots based on a person's specific profile of the industry that they work in. Now, testing, COVID-19 testing and workplace protections, this area is a minefield at the moment, and exactly for some of the reasons that actually I'll say that Franca has actually just raised this morning. With it, certainly around the screening process, on one hand, we are seeing that some of the public health orders are relaxing the mandatory status of the daily attestations or the screening forms, but equally what they are picking up is the requirement that work health and safety rules still require you to take all reasonable and precautionary steps to minimize COVID within the workplace. So under Fair Work Act and the legislation there, all employees, including casual employees, are protected from adverse reactions because they have a workplace right, or they have exercised the proposed to exercise that right as well too. Now, this means that they may have obligations under public health orders. For example, a public health order may require an employee not to attend a workplace for a certain period of time following a positive rapid antigen test or a PCR test as well too. With it, it is unlawful for an agency to take or threaten adverse reaction, for example, firing or injuring an employee in their work employment because of an employee's workplace right. So it is something to be mindful of, that essentially you just because an employee has tested positive, you can't essentially fire them during the course of the employment for undertaking these requirements as well too. Now, there are changing rules that are sweeping through as we're running these sessions, and we will update you around each of these over the next few weeks as well too. Some of these requirements that I will add is affecting the definitions of long COVID, and you will hear us talk about this over the upcoming weeks. Now, essentially what we are seeing is that after an employee may be exposed to COVID or come into close contact or having COVID, essentially they may have common symptoms, even possibly up to 12 weeks after they've had their initial COVID symptoms. So, and these can include things like fatigue, breathing problems, muscle and bone pain, headaches, changes to heartbeat or pattern, nausea, bowel changes, persistent fever, worsening diabetic control, for example, or even sleep problems as well too. We're finding in places like the UK, and we're using a lot of the information from other areas around the world in terms of what they've done. Now, we can see in places like the UK where they have relaxed the rules, but essentially what they have also provided from a public health response is also these initiations around long COVID and also COVID-19 related sickness and absence. Now, this is going to be something that will affect Australian workplaces. We're starting to see it now, and when we talk of workplace laws, we cannot avoid not talking about this as well too, because it will be something in terms of how your agency manages potentially long COVID. What is the requirements that your agency may need to update your policy positions for staff that may say that they've got these particular symptoms many weeks or sometimes even months after they've actually had COVID-19, and how do you manage absences, including sick leave, annual leave, and the likes, where this occurs. Now, current estimates suggest that about 93% of absences related to COVID-19 sickness has lasted for less than 30 days, and over 99% lasted for less than 3 months. But when we talk about COVID-19 within the workplace, we have to then look at that for a small number of staff, this has lasted for a longer period, and how do you effectively manage these practices in advance of them becoming an issue. So we are going to be running these as we're talking about these issues, things that your agency needs to talk about, needs to have policies in places to address these, because this will certainly be an issue from a compliance point of view over the course of 2022 as we move forwards. Now, as we look at also COVID-safe workplaces, we are going to look at, and I'll refer back to this diagram. This was something that was taken from the Department of Health, the Victorian Department of Health diagrams. I'm going to actually mix some of these around. We don't believe in actually recreating and recutting the wheel when we're talking of some of these works. So we are going to, as I mentioned right at the start of this slide, at the start of this presentation and this webinar, that we are going to pick up specific slides from different government departments, different regulatory agencies, and acknowledge them as we go through of where it's come up. This allows us to then very quickly roll this information out to you. It gives you a benchmark for workplace laws within your agency and compliance obligations to essentially start rolling these out within your workplace very, very quickly. Over the next few weeks, we're going to look at the workplace checklist. We're going to update your workplace plans as well too. We're going to look at some of the policy docs around record keeping and HR requirements as well too. I've started to show you how you can actually use your Gemba dashboard to do this as well too. So this is something that is already accessible for your agencies to essentially use. You will continue to get our legal updates within your Gemba dashboard, so that way you can access this information as well. With it, if you do have any more questions, more than happy to stay online as we move through these sessions. I will also mention that we will specifically be looking at a number of key topics as we go through. Next week, we will be looking at workplaces shut down because of agency lockdowns. We will be looking at pay and leave and stand downs and starting to unpack that as your agency needs to meet its legal compliance obligations. Equally, once we do that, we will then be unpacking, as I've mentioned right at the start of this session, the specific tree diagrams for each of your requirements and also updating policies, which we will have a suite of new policies for your agency to also start to utilize as we go through this as well. As I mentioned, if you do have any questions, by all means, use the chat group now. We will also open up the phone lines. If you are watching this recording after today's live session, then by all means, please contact us on 1300 360 360, or you can email us out at support@gemba360.com.